And Rita, remember that
we have to cut this, edit this.
Anything that you put in the chat before people join,
Yeah,
they won't be able to see. So
yeah, I know that was a mistake. Sorry.
oh, sorry.
So I'm going to watch the chat and the Q&A, and I'm saving questions for the end, but I might respond to stuff in the chat, or I might email you if there is a like confusion, and you can decide whether to answer it. Okay.
Okay.
We're at 17. I think you can all see the number of participants, right?
Yes.
Okay. Welcome, everyone. We're going to let more people gather before we formally welcome you. Mark, if you're going to stay on, why don't you stop video as a panelist, you know?
I thought I turned it off. No, can you still see me?
I can, but
I turned off. Well, I'm if you don't need me, then I'll, why don't you, you're on mute.
sorry, it's your picture. It's not you. That's true.
Oh, because I turned off show non-video participants. Or you might have to do that yourself.
Oh, how do I do that?
If you go into view at the upper right.
Oh, I don't see that option. Oh, you know, oh, no, I
See,
don't.
now I'm back. I'm gone. But if you don't need me, you can just text me if you need me. Is that cool?
Okay, sure.
All right.
So welcome. We are going to try to start pretty close to on time so that people who are seeking MCLE credit can get their full hour and a half. So I'm going to make some announcements and then I will repeat them after more people have gathered. But welcome to the how to help your clients with the sex offense tiered registry. In the chat, I'm putting a link to the written materials that go with the webinar. And I am also going to put in the link for you to sign up for MCLE credit. The program today, we're going to go over the tiered registry law and the petitioning process, and we'll be sharing tips from practitioners on, you know, how to best represent your clients. Okay, so they didn't link. I'm going to, after I stop talking, I'm going to put in new links that should be clickable. Sorry, I thought they would automatically turn into links. We are using the question and answer feature, which is at the bottom of your screen, for questions to the panelists. We will be answering questions at the end of the program around 4:15. I will also keep an eye on the link on the chat, excuse me. So I'm going to do introductions. My name is Rita Himes. I'm a staff attorney at Legal Services for Prisoners with Children, and we helped organize this training. We help lead quarterly discussions among reentry service providers, including legal aid organizations across the state. Out of those discussions, there was, a lot of questions about how to effectively represent folks trying to get off the registry. And we know Alliance for Constitutional Sex Offense Laws, which you'll hear referred to in shorthand as AXL, are experts on this issue, and they agreed to help us present this training. We are also fortunate to have a skilled public defender who's leading her office's work on this issue. So I'm going to briefly introduce everyone. Then I'm going to go over the logistics again, and then we'll start the program. So we have Janice Belluci, who is the executive director of AXL, the Alliance for Constitutional Sex Offense Laws. Janice used to be an aerospace attorney and counsel to the Space Subcommittee in the U.S. House of Representatives. She now is a civil rights attorney, and her entire practice is focused on registrants and their family members. She is the executive director of AXL. She's been recognized as one of California's top 100 most influential attorneys. And she will be leading our presentation today. We also have Chance Oberstein, who is the president of the board of directors for AXL, the Alliance for Constitutional Sex Offense Laws. Chance has a long history doing criminal defense work. He's handled hundreds of cases involving misdemeanor and felony crimes at the state and federal level. He's been recognized by the American Institute of Criminal Law Attorneys as one of the 10 best criminal law attorneys for client satisfaction, and he received the Albert Nelson Marquis Lifetime Achievement Award this year. And finally, we also are going to be hearing from Carlton Morse, who is a legal assistant at AXL, again, Alliance for Constitutional Sex Offense Laws. And finally, we will be hearing from Michele Kumaus, I hope I pronounced that correctly, who is leading the Fresh Start unit in the San Diego Public Defender's Office. Michele has many years of experience doing trial and appellate work for private criminal defense attorneys, and also as a deputy public defender, handling misdemeanor and felony cases from arraignment to trial and sentencing. So she's currently working in the Fresh Start unit and is the point person for tiered registry petitions. And as you will hear, her office really stands out from the crowd in terms of effectiveness of processing these petitions. So again, I am going to put in the chat a link for the written materials and for a form you should fill out if you want MCLE credit. I'm gonna find an effective link and add that to the chat while the panelists are speaking. I want to remind you to put questions in the question and answer period. We're going to answer questions at the end of the seminar beginning around 4:15. And now I'll turn it over to Janice Belluci.
Okay, well, thank you, Rita, for that kind introduction. I appreciate you organizing this event because it's very important. We have a relatively new law, which was passed way back in 2017, but did not become effective until January 1st of this year. And quite frankly, only part of it became effective on January 1st. And I would argue that the most important part of the law did not become effective until July 1. So we've only had about 4 months of dealing with that part of the law. And so we're going to talk about some background information about the law. So let's go on to the next slide, please. All right, so the very first bullet, 7 years of lobbying. I will tell you that 7 years of hard labor here in Sacramento and trying to get the attention of legislators who have a lot of other things to do. and who basically did not feel comfortable passing this legislation until a really broad spectrum of parties came together. And finally, in 2017, we did get a tiered registry law. I'm going to be telling you in a minute that it's not the tiered registry law we asked for, but it is a tiered registry law and something that we can improve upon. So on this slide, there's 3 different bill numbers. And the reason I thought it was important for you to know this information is because some people might refer to it by other bill numbers, but the last number there, 384, is in fact the final bill number. And so I'm kind of surprised that people are still referring to the law as SB 384. I guess maybe that's easier to say than tiered registry law, but the fact is they're one and the same thing. It used to be Senate Bill 384. It was passed by both houses of the legislature, signed by the governor, and again, it went into effect on January 1 of this year. So the original bill that was introduced, and that was way back as Senate Bill 695 with Senator Lara, it would have benefited 90% of the registrants. And by the way, it also would have been based upon risk level and not the offense for which a person was convicted. So let's go to the next slide, please. The final bill does in fact benefit a lot fewer people. 90% was the original bill, 60% is what we got. And for those of you who have not been part of the legislative process, I'll just warn you that what you put into the sausage machine is not necessarily what comes out of the sausage machine. Actually, it rarely is. So again, we asked for a tiered registry that was based upon current risk level, and instead we got one that was based upon conviction offense. So because of that, this bill is not going to benefit anybody who's been convicted of a felony offense involving child pornography. I prefer using the term unlawful image, but I'm not sure everybody's familiar with that term, so I use the term that's in the name of the bill. So again, we're talking about felony CP charges. If it's a misdemeanor CP offense, you're in tier 1. And by the way, if it's a felony CP offense, you're in tier 3. And this in fact does include possession. Again, felony conviction for CP possession, you're going to end up in tier 3. We'll talk about that a little bit more. And also the final bill also doesn't benefit people who are convicted of two or more separate felony sex offenses. And so what that means is if you have one case and maybe your client was charged of 3 separate sex offenses, but in fact they all occurred in the same really area of conduct and probably with the same victim, then it's possible anyway that could be considered a single felony sex offense, and that they might in fact benefit from Senate Bill 384. But the fact is, if in fact your client has multiple sex offenses that were felonies, he or she's not going to benefit from the Senate bill. So next, please. So in the past, everybody convicted of a sex offense basically was assigned to the same tier, and that was lifetime. You got convicted of a sex offense, you're on the sex offender registry for life. And since our registry in California started in 1947, we have some really, really old people and old offenses. And as we practitioners are finding out, it doesn't make any difference if you might have been convicted of 3 other felonies after that point in time. They're still going to call you a sex offender, and they're going to still treat you as a sex offender when you're on parole, which I won't go into right now. But so the benefit of this tiered registry is in fact it creates 3 tiers, and that means that there are in fact possibilities for some people to get off. Now, this is what I call the golden ticket. If you get a tier assignment letter that says you are in tier 1, you have the golden ticket. In some of the jurisdictions now, the DA's offices are not opposing a person who has a tier 1 assignment, and things are moving a lot quicker and more smoothly. But I will tell you, there's some real mismatches here as far as who ends up on tier 1 and who doesn't. For example, as the slide reflects, it says most misdemeanors are on tier 1, but quite frankly, not all misdemeanors are on tier 1. And Chance will be addressing that later on in this presentation. Also, nonviolent felonies, as most, but not all, are on tier 1 as well. And so if you're lucky enough to be assigned to tier 1, your requirement to register is a minimum of 10 years. And there's possibilities that more time could be added. Chance will be going over that. And also there's tolling, which you end up looking at your entire criminal record, and that's going to decide when you are eligible to petition. Now, if you get a failure to register, it doesn't mean that you can't that you're ineligible to petition. It just means you have to wait longer than the minimum. So let's go to the next slide, please. Okay, I said there's 3 tiers. Here's the second tiers. So we do have some violent felonies on tier 1. And the biggest example, and that's why it's here, is Penal Code Section 288, parentheses A. And so there used to be a 288A, and that got changed, the numbers, and it's confusing. I mean, when I had somebody call me up and say, oh yeah, I was convicted of 288A, and then I started asking them questions, so many times they don't know themselves what they were actually convicted of. Now, if they're on the Megan's Law website, that gives some information, assuming it's correct. But anyway, the reason this is so important is we probably about 40% of the people on the California registry these days were convicted of this one offense. And I still don't know why. We have Alfred pleas out there, that's for sure. A lot of people tell me, yeah, that's what I agreed to plead guilty to. However, I didn't do that. I did something else. And so maybe someday a prosecutor will let me in on the secret as to why so many people were convicted of 288As. But the good news is they're on tier 2. And I say that because we have another offense that's very similar that's on tier 3. And I'll tell you how crazy that is. There is an exception here, and that is noted on the slide. If the defendant is less than 21 years old and the victim's 14 to 17, plus some other conditions, they might be able to petition after 10 years. But most people who are assigned to tier 2 have a minimum registration requirement of 20 years. Next slide, please. Okay, so this is tier 3, the place that you don't want you or your client to go, if it's at all possible. And the reason I say that is if you're assigned to tier 3, this is lifetime registration. So California's had lifetime registration for most people for decades, and this is really kind of the same. However, it's even worse because just if you think about it, if you have people assigned to tiers 1 and 2, oh, now they look like they're not as bad as tier 3. Or put it the other way, that somebody assigned to tier 3 must be worse and pose a greater threat than somebody on tiers 1 and 2. I don't believe that is true. And part of this, quite frankly, has to do with the legislation itself and who ended up in tier 3. So here we go. Repeat violent felonies. Well, to me, that kind of makes sense. Okay, you have somebody who's been convicted of multiple violent rapes at different times, different victims, etc. Okay, well, maybe they belong on the highest tier. But quite frankly, I can understand why CP offenses are on tier 3. And there's no secret about this, folks. And if you're wringing your hands about this and going, how can this be? This is not logical. It's not reasonable. I agree with you. This is the result of a political compromise. So in the legislative process, political compromises happen, and they don't have to have any reason or rationale for it. So there was a group of people, some people attribute this to law enforcement, who said, we will not sign on to this bill unless you put all those CP offenses on tier 3. And again, this is felony CP offenses on tier 3. Now, that doesn't make sense. The next one makes even less sense. So people convicted of Penal Code Section 288C, right? So if you know the difference in the Penal Code sections here, 288A, remember, is on tier 2. By the way, that's a victim under the age of 14. 288C, your victim's 14 or 15. And yet C is on tier 3 and A is on tier 2. So Chance will be talking about this as well, and the fact that there's litigation pending challenging these tier assignments, actually the 288C. So how else can you end up here on tier 3? Most of this is done by conviction offense, but there's a nasty little exception here, and that is if you have this risk score that's considered well above average, you're going to end up on tier 3. And it is possible to have a tier 1 offense. So let's just talk about, PC 647.6 or molest If you are convicted of that, you should be on tier 1, unless, here you go, you have a risk score of well above average. So what that means, by the way, in numbers, I hope you all are familiar with the static 99 instrument, shall we call it? And it has numbers. So well above average is considered 6 and above. It goes all the way up to 12. So 6 through 12 is considered well above average, and that's going to put you on tier 3. Okay, there is an exception, kind of like tier 2, there's an exception. There's a small exception for tier 3 as well. And you can petition after 20 years if the only reason you're on tier 3 is your Serrazzo score. So again, you have your score is 6 through 12. And I have to admit, that is pretty high, by the way, because it goes all the way to -3. So -3 all the way up through 5, that is not well above average. So this time you have to score at least a 6 or higher to end up on tier 3 because of that. But again, if you're that tier 1 offender, you're convicted of a tier 1 offense, and yet you end up on tier 3, you do have this escape clause here, which in fact would allow you to petition after 20 years. So Carlton, next please. So here we go. What about the tiering and some of these exceptions and some of these nuances, I guess. If your offense is considered, it's of non-California conviction. So what do we mean by that? If you're convicted in another state, if you're convicted by the federal government, or if you're convicted by military court, what do you do then, right? So what DOJ is supposed to do is they're supposed to look for the California equivalent. By the way, you're not supposed to be registering in California unless there is a California equivalent. And I find it quite surprising that in many cases, DOJ is taking a long time to determine somebody's tier when they have like an out-of-state conviction. And I say that because they've been requiring you to register for years, and yet they can't tell you what the equivalent offense is. Oh, well, I digress. So then we go, okay, well, what if there's no equivalent offense in California? Well, then you're going to look at your risk score, right? So anyway, and then they're going to look for these other types too, including whether or not you've ever been subject to something like SVP, stands for sexually violent predator, some type of commitment, and that would be again in another state or possibly in a military situation. Next slide, please. Okay, so there are exceptions to everything. So let's just talk about here. This has to do with eligibility. So it's not a question about how many years you've registered. If you are in these categories, you are just not eligible to petition at this time. So here we go. You have pending charges that could extend the time to register or change your tier status. This is a relatively new law. I haven't encountered this yet, but I guess it's theoretically possible. But the next one I have encountered, and that is a person's in custody, somebody's on parole, probation, or supervised release. If you fit any of those categories, you are not eligible to petition. I literally have had relatives call me and one man from prison call me saying, hey, how do I petition for removal? And I have to tell them, because you're in custody, you're not eligible to petition. And oh, by the way, you probably don't have enough years in either anyway, but this is really important for you to know. And by the way, we're not talking about being on parole, probation, or supervised release for a sex offense. It's for any offense. So you have somebody who had a DUI, but they were convicted of a sex offense long ago, and they are on probation, parole, or supervised release for the DUI. The fact is they have to wait until that is over before they are in fact eligible to petition. So next, please. Juveniles, on those other prior slides, I hope you saw the word adults there, because there are different tiered systems for adults and juveniles. People tried as adults and people tried as juveniles. I haven't found a person yet who really qualified as a juvenile offender. Maybe Chance has, and he'll talk about that when he's speaking. But the fact that the reason I say that is a lot of people who might have been 17 years old at the time that they were charged and convicted, but they were tried as an adult, or they were tried even in a juvenile situation, but they were put on probation, and if they violated probation, then it would fell back to being tried as an adult. So this is theoretically possible, but I'm just going to tell you, I haven't encountered it yet. But just say if you do find this person, maybe I'll call them a unicorn, that in fact their tiers are a lot shorter. There's a 5-year tier, there's a 10-year tier, and nobody is on for a lifetime. So that's the really good news. They don't have a tier 3 that requires lifetime registration. So happy unicorn hunting. Next, please. Okay, so how about tier assignments, and are they going to be listed on the Megan's Law website? Right now, just so you know, static 99 scores and some other like LCSMI, they are listed on a person's profile on the Megan's Law website, but supposedly it's not going to happen. So anyway, that's the going in position, subject to change, but I'm not sure how I feel about that, but that's what the law says. So tier assignment levels are not going to be on people's profile on the Megan's Law website. However, there are going to be a lot more people added to the Megan's Law website. And Carlton's going to talk about that in just a moment. So I'm going to go to the next slide. Okay, so how do we calculate this registration period? Remember, tier 1, minimum of 10 years. Tier 2 is a minimum of 20 years. Tier 3, again, is lifetime, and those folks are not eligible to petition. So you count from the time, or the date rather, of your release from custody. Now, for some people, they've been in prison for 20 plus years. Some people, they spent 2 hours in jail, at the jail rather, just getting booked, and that's the only time. It doesn't make any difference, okay? It's whenever you're released from custody, right? And it does not include the time that you're on parole, probation, or supervised release, which is really good news, because in California, some people on parole are on parole for 20 years, right? And if they had to wait if they didn't start counting until completion of parole, that would really extend the time. But again, you start counting from the date of release from custody. And this is the next bullet's really important too, that each time somebody's convicted for a new sex offense, the minimum registration period starts again. It starts all over again. So most people, by the way, don't have more than one sex offense, despite all the scary stories that are told by the media and others. Most people have one sex offense. But okay, so also when I want everybody to know FTR, which means failure to register, and thanks Rita for explaining that in the chat room, that a failure to register is not a sex offense. So a lot of people are confused by that, and they think that, oh my gosh, if I got a failure to register, then whatever's going to happen after that. But as we'll talk about shortly, the failure to register does affect how much time you have to wait before you can submit your petition. Next slide, please.
Janice, just there's a lot of confusion in as far as when the time starts, and we get this all the time. And one thing I just want to reemphasize here, and you said begin counting from the date of release, which of course is so. But if for instance there was no time, if they didn't get credit for any time, if they weren't given any time, then it's the start of their supervision, which means probation. Or when they were put on probation, which is when they got sentenced. I just want to make sure that everybody understands that, because it's not just one size fits all here. It deviates a little bit.
Mm-hmm.
Okay.
Thank you for that, Janice.
You're welcome.
Next slide, please. Okay, so what happens if you were convicted of failure to register? For each conviction, if you were convicted of a misdemeanor sex offense, you add 1 year. So let's just say that you were convicted of a misdemeanor offense. You're going to be assigned to tier 1. You have a minimum of 10 years. If you have 2 failures to register, they're going to be misdemeanors. But what it means is instead of 10 years, you're going to have to wait for 12 years, at least 12 years before you're eligible to petition. So that's misdemeanors, and 1 year per conviction there for failure to register. If you were convicted of a felony sex offense, however, is 3 years per conviction for failure to register. And you can imagine that adds up relatively quickly. And we have people who get convicted of failure to register for all kinds of reasons. We're not going to go into that right now. But in fact, it's really important that you know that as a practitioner, you know if in fact they've had a failure to register. And I believe in the materials that you'll be provided, you'll see an example of a CSAR sheet that in fact captures how many failures to register a person has. And so what happens is when the local law enforcement is making a determination about whether or not your client is eligible to petition, they're going to count each and every failure to register. So that's really important that you need to know that. Another thing, and this last point here has to do with tolling. And so when your client goes back to custody for any reason, it could be a parole violation, it could be another felony offense, or another misdemeanor offense, whatever the reason is, that amount of time is not going to count toward the minimum amount of time they spend on registry. And so for some people that have a pretty long criminal record, it's going to take some time to calculate that out. And by the way, what we think as practitioners doesn't count. It's going to be what the local law enforcement thinks and what DA thinks. So we can always disagree with them in a professional manner, of course. But anyway, for some clients, this can be really difficult, challenging to figure out. Next slide, please. So one of my favorite topics, tier assignment letters. The reason I say that is that lo and behold, the California Department of Justice told me personally that they didn't have enough resources to mail tier assignment letters to people on the registry. Isn't that curious that a state agency would lack those resources? I find it hard to believe, quite frankly, but that was their position. So instead of mailing letters out to registrants, what they did is, yes, DOJ created the letters, but then they dumped them into this government-only database. And the acronym is CSAR, C-S-A-R, which stands for California Sex Offender and Arson Registry. So as practitioners, we don't get to look and take a peek in this database, except as I'm finding out now, in these petition cases, sometimes we get to see a page or two out of the database, but it's really causing some problems. And you know, the registrant has to go to local law enforcement, the place where they register, and ask for a copy of their tier assignment letters. In some jurisdictions, that's fine. With a smile on their face, the registration officer hands the tier assignment letter. And other locations, that's not what happened at all. And I know the city of Long Beach, for example, they initially refused to hand out anybody's tier assignment letters. And I had to go to California DOJ and get that corrected. I've had to do it with a few other jurisdictions as well, but Long Beach was certainly the largest one. They wouldn't hand these out. Some jurisdictions are saying, oh, you have to wait till your birthday. Nonsense. Okay, according to California DOJ and their answers to frequently asked questions, they put on there, these letters are available starting January 1 of this year. So here we are, you know, it's almost December, will be tomorrow, and everybody should have their letter. Now their letter might say tier to be determined, and Chance will address that later, what that meaning is, but there's still a letter, and your client, the registrant, does have, I think, a legal right to get them. So next slide, please. And then we have some other issues. Remember how I said that we've got some misdemeanor offenses on tier 1? Unfortunately, that is true. And we have some felony offenses on tier 3, which makes sense. But we have some people who were initially convicted of a felony, which was a wobbler. They had it reduced to a misdemeanor, and yet California DOJ is treating at least some of them as tier 3. And here's a couple of examples: the 243.4 sexual battery. I mean, there's all kinds of subsections for sexual battery. I'm not going to get into that right now, but some of those are wobblers and or a misdemeanor. The people who have out and out misdemeanor of 243.4 is not a problem, but we have the people who were originally convicted of felony 243.4 who in fact got it reduced, and that's not automatic, as we all know. They went to the trouble and expense to have that done, And then DOJ is ignoring that and say, oh, well, you were convicted of this, and so we're going to assign you to tier 3. So the reduction for all purposes, there's lots of case law out there that says when you get a reduction, it is for all purposes unless the statute says otherwise. The statute does not say otherwise, and therefore we believe these folks who were convicted of a wobbler that has been reduced to a tier, reduced to a misdemeanor, that they belong in tier 1 and not tier 3. But we're still having arguments and discussions with California DOJ about that. Next slide, please. So, Fulton, I believe this is for you, and we talk about the Megan's Law website.
Yes, so thank you, Janice. The tiered registry law also makes changes to the Megan's Law website. And those changes, though, don't go into effect until January of next year, January 1st, 2022. Some of the changes are good, some are bad, depending on where you fall. The statute that governs this is the same statute that governs the current Megan's Law website, Penal Code 290.46. And in general, tier 1 registrants are not posted on the Megan's Law website at all. And tier 2 registrants are, but their street address is no longer listed, whereas it usually is for most people now. Tier 3 registrants have their street address listed. And if you're assigned TBD, right, per the letter, the statute says that you may be posted on the website. But that, that presages some of the ambiguities of the statute. We're not quite sure what the DOJ is going to be doing because there's a lot of maze in the statute and apparently some discretion. The people who are concerned the most about this are, in general, folks who are not listed on the Megan's Law website right now, either because they satisfy the current statutory exclusion, or the DOJ has apparently exercised its discretion to just simply not post them. The DOJ has acknowledged in its FAQs that the new exclusion is narrower and that there will be people that are posted on the website as of next year who aren't currently posted. One question that arises is whether, if a client is not on the Megan's Law website now, will that person will their exclusion be maintained next year without having to reapply for it? The answer is we don't know. The DOJ suggested in its FAQs that it may keep folks off, but there's also the application procedure. It's pretty clear that if you intend to take advantage of the current exclusion, they want you to apply for it. So we've been proactive with clients that approach us with this issue, and we've applied on their behalf for an exclusion starting in January, a renewed exclusion effectively under the new law. If per the law, a client is going to be listed on the Megan's Law website who is not now, the statute says that the DOJ must attempt to notify that person 30 days before their profile is posted. The new statutory exclusion for the website is generally folks who are closely related to the victim, either a parent, step-parent, sibling, or grandparent, and the offense didn't involve certain factors. Those are just listed in the statute. And they also need a risk score of average risk or below. And the statute also says that really anybody, apparently even those, apparently or maybe folks who are already excluded from the website under the relevant exclusion need to apply for the exclusion going forward after January. But neither the statute nor the DOJ says how to apply for it. The current statute says that one must use the form that DOJ provides for that purpose, but the amended statute effective next year doesn't reference a form. So we'll be learning how exactly to apply. We've sent letters, just articulating why someone meets the exception, but there is no form as yet. The DOJ may publish one. So the next topic is the process, the mechanics of removal. The first step is filing the petition. Removal is not automatic from the registry, obviously. The court must order it in response to a petition. The timing of the filing is currently governed by what we call the birthday rule, which basically says the first date you could file a petition was July 1 of this year, but the statute was amended right before it became effective. It was amended to prevent everybody who's suddenly eligible from petitioning right on that day. And the law says that if you're eligible because you've registered already for the minimum time period applicable to your tier, you have to wait until your next birthday following July 1. And so it's staggered out the petitions. The birthday rule becomes irrelevant though after next June. Anybody who after next June 2022 who's registered for the minimum time period is free to petition regardless of when their birthday is. The petition is filed in the county where the registrant currently resides and is registered. And it is to be served on the district attorney in the same county and also on the law enforcement agency with whom they register. So if they live in Orange County and they register with the Santa Ana Police Department, the petition is filed in the Superior Court Criminal Department for Orange County and also served on the district attorney for Orange County and on the Santa Ana Police Department. If the registrant was convicted in a county other than the one that they're filing in, other than the one where they currently reside and are registered, the petition needs to be served on the district attorney of that county where they were convicted and also on the law enforcement agency in that county. This is we think a significant ambiguity in the statute. It's easy enough to find out who the district attorney is because there's only one per county. But in terms of the law enforcement agency, it just says the law enforcement agency in the county of conviction. But that could be the agency that arrested you, the agency that investigated the case, perhaps where you registered immediately after you were convicted, if you didn't have a custodial disposition. And so we're not quite sure. The safe course would be to serve it on all those agencies. Sometimes the client doesn't remember which agency was involved. Live scan reports often seem to indicate at least who the arresting agency was, so that's a clue. One district attorney's office told us that they're interested in seeing served the law enforcement agency that investigated the case. Which is a good agency to serve regardless, even if they were perhaps registering with a different one. Registrants who have a conviction not in California, so a foreign conviction either from a different state or a federal conviction or military conviction, it is not entirely clear whether the law enforcement agency, the relevant enforcement agency and the relevant prosecutorial agency needs to be served with this petition also. We think probably not, because the statute uses terms that only make sense or that assume a California conviction. For example, they talk about the district attorney and the county of conviction, registering law enforcement agency, and there's no district attorneys, for example, at the federal level. So who would you serve? But the DOJ has declined to give guidance on that so far. And there's been some discussion, folks who talked about the practice in this area, in an abundance of caution, could one serve the prosecuting entity and also the law enforcement agency that had investigated the case in an abundance of caution? The risk there is that it would seem to invite objections or comment from an agency with no standing to comment on the petition, which could cause some problems. But hopefully there's guidance on that coming soon.
Okay. Thank you, Carlton. Are we doing this together, or shall I just start out?
No, go ahead, please.
Okay, we'll jump in if you feel like you want to. But right now we're shifting away from the mechanics of actually petitioning, because the petition is a couple of pages, and then you attach a proof of current registration to that, and that's what you serve on everybody. That's what you file in the court, and that's what you serve on the folks, the local law enforcement agencies and the DA's office. Okay, then what happens next? Then we get into process, consideration by local law enforcement to determine if the registrant is eligible to petition. Okay, so what we're focusing on here, at least for the moment, is we're focusing on law enforcement and what they do. What they do is they determine eligibility. So they've got 60 days to do that, and based on what they do, a consideration, DAs then consider what they see and decide whether or not they're going to object or going to stipulate. Now, you have a sample petition checklist, which Janice was referring to as the CSAR, the CSAR sample. And it's interesting because in terms of eligibility, when you submit your petition and the law enforcement agency goes to work to determine whether or not a person actually is eligible, you can look and see the reasons on the, I believe it's the second page, of why a petitioner may not be eligible. One is they're a tier 3 by way of background check. 2 is petitioner has indicated eligibility for early termination pursuant to a tier exception and does not meet the requirements for early termination, and so forth. You can look down that list. There's a lot of reasons why a person can be eliminated from contention or considered eligible. It's funny because I'm looking at the sample here, and the 2 things you really want to do when you submit your petition is, 1, make sure that you filled it out properly and not missed a thing. And the other thing is you want to make sure you submit a current proof of registration, which is not an annual registration, but actually a document that is a DOJ document. It's 2 pages that needs to be attached to the petition. In this particular sample, it says proof of current registration attached to file or to petition. No, but are they otherwise eligible on second page? Yeah. Interesting, right? So, we're just at the beginning of all this, and, we're kind of forming it as we go along in terms of the process. And so just things to consider. All right, so again, both entities have 60 days to make a determination. Carlton, next slide. So process for removal, continuing. Basis for DA's responses per 290.5A. And it's important, I think, for every practitioner to just open up the book, open up the penal code, take a look at the law. PC 290, it's ugly, it's convoluted, it's worse than character evidence, I guarantee it. But it's nice to look at it and try to understand for yourself what it means, what it says. So here's 290.5A. Lack of tier designation. Okay, the first thing is to be determined, why do they have that? Why is it that some people are classified as tier 1s, some as tier 2s, some as tier 3, and some as, we don't know. Most of the time that has to do with a foreign jurisdiction. Someone out of this, a conviction that happens out of the state of California, as Janice said before, it may be military, it may be state, it may be federal, but it's not California. And so it may take some time to figure out where that falls on the tier, if there's an equivalent, and if not, just to shove it into tier 2 and say, okay. So, that takes time, and the DOJ has about 2 years to do that. Why is it that some in-state folks get that letter? I don't know, but I can tell you this much. It certainly happens a lot with people who have older cases. So I have a supposition. My guess, my best guess is that before the DOJ designates or actually says this is what it is, they want to match the information they got originally from the jurisdiction of the conviction. They had to receive some paperwork, they don't prosecute. So they've got to receive it from that jurisdiction. They've got to match it to what they've actually put on their records to make sure it's true and correct. My guess. So it takes time. That is a real problem in terms of lack of tier designation. And that is because when you have someone who has a conviction in state, and you can look at the CSAR form again, you can see how they do this. They look at the federal criminal background, they look at the state criminal background. If in the state criminal background, they have one conviction, it's for an offense that maybe is on tier 1 or 2. There's no failures to register. Certainly everything else works, they're otherwise eligible, but yet they're to be determined. My supposition and the way I see it is there's no need for the DOJ to designate because we can all see where they fall. And so to me, that's not really a to be determined, but it's classified as that sometimes by the DOJ. Those cases I go forward with on the petition. There are other cases that I'm a little bit hesitant on, yet to really understand how this is going to be handled by the DOJ, and that is out-of-state convictions, because that I think is what this category is really for. When a person is ineligible, well, when they're considered ineligible, of course, the DA is going to say, no, no, you can't petition. And If that ineligibility is based on inaccuracy in the record, or it's based on other things, other variables, that's fixable. When the comment at the end of the analysis is, and the objection comes to community safety will be significantly enhanced by continued registration, then I think you have an evidentiary hearing coming. And we can go on to the next slide. Okay, which means after that analysis by the agency to determine whether or not a person's eligible, and once the DA concludes how it's going to position itself, it could either stipulate or object. If the DA objects, it could be a summary denial. It may be that something in your petition is wrong. It could be that you missed a box. It could be that something needs to be corrected. It could be that you missed service or process on someone important, maybe even from the original jurisdiction. That can be fixed. But when it's a hearing on the merits, that calls for something altogether different. That's an evidentiary hearing. And when you have an evidentiary hearing, they're going to come up with some items, and usually the items that they come up with, well, let's put it this way. They're out there. You can see them for yourself. I mean, the analysis is going to be pretty checklist, and it's going to come down to factors, and we'll go through those factors in a minute. And then you're going to have an evidentiary hearing, and of course, registrants may be represented by counsel. Okay, next slide, please. Okay, the judge is going to make a final decision regarding this evidentiary hearing. And these factors I was just talking about are listed. Okay, and you can find them there in 290.5, but there are pre-conviction factors, and some of which are the nature of the offense. The nature and character of the offense. Is it aggravated? Were there multiple victims? Age and number of victims count, whether a victim was a stranger, and you can see the rest inside the statute. But basically, it's what may, when you're looking at the nature of the offense, it could be what aggravates, or it could be what mitigates. Could go the opposite, because for every aggravating factor, there's a rebuttal, and the rebuttal usually is in the form of other factors that I'll go to in just a moment. Next slide, please. Okay, again, judge to make final decision regarding the petition, post-conviction factors. Here's the rebuttal stuff. Okay, time period without offense. Well, let's just say that it's been 20 years. They did really well in their treatment program. Their current risk offense is like 0 or 1 or maybe even 2. Those are really important things because it shows that they're no longer a risk. And after all, this is not relitigating the initial offense. This is to determine whether a person should be removed from being monitored. So of course, risk is really where the rubber meets the road here. And so these things here, these factors are really, really important. Okay. And we have at bottom here, and I'm pretty sure we're going to go through these in the question and answer period, and I'm talking about the factors that I just spoke about. But after it's all said and done, the DOJ is supposed to send a letter to confirm termination or registration requirement within 30 to 90 days, if of course the judge decides to remove. Okay, next slide. Okay, judge's decision re-petition. Okay, that's to be sent to the California Department of Justice, be transmitted to them. Okay, if it's not, you're not going to be removed. Because a court says you're removed doesn't necessarily mean you're removed. You've got to be removed when the Department of Justice takes you off. So as a lawyer, if you get a removal, and you don't hear from them within a reasonable time, and that would, for me, be at least 3 weeks from the date of removal. You contact the Department of Justice and nudge them a little bit to make sure that they do what they're supposed to do. If the hearing is held and the petition is denied, the judge determines when the registrant can reapply, and Janice went through that before, but that could be 1 to 5 years. And of course, the judge's decision can be appealed, and I'll leave that to Michele to discuss, because you know, there are some interesting nuances in that. If Michele feels free or feels like she wants to get into that, I'll leave that up to her. Okay, next slide. Okay, petitions that have been granted. This is really good. Los Angeles, unopposed petition for 288A conviction granted. Well, not only Los Angeles, but San Diego as well. And kudos to both Janice and Michele for doing that. There has been an unopposed petition where unopposed petition where the tier for the California conviction was granted for a to be determined. That was my case. And again, we went through the initial process of petitioning. It was interesting because there was an objection by the DA's office, and the idea was that the DOJ hasn't designated yet, and I had to point out to the DA that they don't need to for the factors that I discussed with you earlier, which is this was an in-state conviction. It was easy to see. There was no federal convictions. There was no failures to register. There was nothing out there to toll the statute or to add anything to it to aggravate it. It was very clear to determine that it was tier 1. And so they stipulated, the judge agreed, granted it, and I'm very happy that happened. San Diego, I really got to comment on it. I got to say, they are probably the most well-organized jurisdiction, to my knowledge, that there is in the state. And look at them. It's not 55 petitions anymore, it's 60. And I think 23 now granted, including PC 288 convictions. Why is that? Well, because you've got the public defender's office, you've got the DA's office, and you've got the judges, and they're all in sync and they're all working together and they're processing these things the way that the law says that they should be processed. They're actually doing exactly what we'd expect them to do with this new law. And it's amazing, and it's wonderful. And I've just really got to commend them. Okay, next slide, Carlton. Okay, so preparing to petition. Okay, what do you do when you get ready to prepare a petition? Do you just grab the petition, fill it out real quick and submit it? I don't think so. You got to think it through a little bit. One, you got to gather some information. Now, tier assignment letter and the CJIS form 8050, which is current proof of registration, those are the two must-haves you must have. But I think you really need to think a little bit more about that. That's just a mechanical application of what you need in your hands to fill out before you can file and serve and start the process. What you want to do before you do that is get to know the case a little bit so that you understand what's going on, so that there's no surprises and you can effectively represent your client. That's a whole different thing. And I'm going to make some suggestions here. The tier assignment letter and the 8050 form, well, those are things you need to complete the petition. But the live scan report, and I'm not sure if everybody knows what a live scan report is, just simply a criminal background. It can be done at a local law enforcement agency, or you can go to the UPS and do it. Teachers do it. All kinds of folks do it, but you can do it for personal reasons. And it's important that your client does it, because you want to look at that and see just exactly what's there. That's their criminal background. And of course, that's what's going to be considered. That's what the DA is going to look at. That's what law enforcement is going to look at. So you want to get a look at it too, to understand just exactly what your client's chances are and where they fall. Because the first thing you want to do is determine what their conviction is. And a lot of folks don't even know that. They think it's PC 290. It's not. That's in the penal code. That's where you go to find the law regarding how to proceed. How to define the class, the tier, how to proceed. But it's not their conviction. Got to know their conviction. So live scan report is really helpful. 2, a docket, probation, or pre-sentence report, the underlying case file. Those are all things that you should look at, because you want to understand the facts and circumstances of the case. You want to determine what the potential risk is. You want to know if there's anything out there that's going to cause you to stumble in this removal process before you ever get it started. You want to check for failures to register, and you want to look and see whether or not your client can benefit from potential reductions and such. And you want to really, if you can, and if your client has them, read the risk assessments, because those forensic evaluations, those psychological evaluations are really, really, really important, because they're going to come back later, believe it or not, and bite you if you don't know what they say. You don't want at the last minute to have an objection over facts and circumstances, or risk and then be the last one to read the evaluations. And it would help to possibly have a new evaluation done if, of course, these are old and stale evaluations. Okay, next slide, please. All right, here we are. Legal challenges to tiering. Well, I think that Janice can speak to this. We have, as an organization, the Alliance, we are in the process of litigating 288Cs. Why? Because 288As are in the 20-year category. I always look at a 288C as a lesser threshold offense. It's a wobbler, it can be filed as a felony or a misdemeanor. If it's a misdemeanor, it's far less serious than a felony 288A, in my opinion. And it's up there in tier 3 because, funny as it may seem, in the classification scheme, when this was all thought out, the whole section wasn't included, just 288As. And so it creates an anomaly. The misdemeanor 288C sits up in tier 3. Janice, a word?
Sure, Janice, thank you. The lawsuit that we filed, and I think we filed it in February of this year, here in Sacramento, is basically we're using equal protection as the legal claim, because again, it seems common sense to me, and I hope to you as well, that somebody convicted of basically the same conduct with an older victim should not be on a higher tier. But this is one of those, I think this is part of a political compromise, or just might have been a typo. I'm not sure which it is, but we're at this point in time not able to get any legislative changes to the tiered registry law. The folks who are here in the state capitol, they said they want to see how things shape up with regard to the law. And oh, by the way, it's an election year next year. So so nothing's going to happen the rest of this year, which is almost over, and then all of next year. But we are really expecting in 2023 to be able to at least potentially go in and ask for some changes. But back to the 288C versus 288A, I will say there are a lot less people have been convicted of 288C. However, it's really created a mess. And for example, I spoke to somebody just last week who told me that when it came time for him to plead guilty, he could have pled guilty to 288A, but his attorney suggested he plead guilty to 288C because it was a lesser offense, just like you said, Chance. And so here he is, he's stuck in this deep hole because he in fact pled guilty to 288C. So I think that's something that eventually will get fixed, if not through litigation, through legislation, but it's not going to happen anytime soon.
Okay, so it goes back to what I said earlier, which is know what your client's convicted of. Okay, 2, the other 2 things, the felony CP offenses on tier 3, including possession, while contact offenses are on tier 1 or 2, was a political decision, as Janice said. And as you know now, some misdemeanors reside on tier 3. We don't need to go back a slide, Carlton, or anything like that, but I want to reemphasize something before I end. And that is that once you determine, what the conviction's for, it's easy. You can make a checklist for removal. And this is just a practical tip, so I'm just going to put out a few things. You can add or subtract from them. But remember what I said to begin with. There are things that you need to complete the petition. Those are that is the forms and the proof of current registration. And then there are things you need to determine the conviction, the aggravating or mitigating factors, and also risk. But I have a checklist once you know what the conviction's for, and I'm just gonna say it real quickly for you, and I hope it's beneficial. But know when your client was placed on supervision and or released from custody. We've gone through that before, but that after you know what the conviction is, that's the next best thing you need to determine. Okay, and again, we've spoken about how to do that, but you need approximate dates of sentencing and release. And you can get that through pre-sentencing reports prepared by probation, get them by a sentencing sheet or a waiver form. And you can also get it from the electronic docket, the original jurisdiction, by going to the clerk of that court, the criminal clerk of that court, in requesting it. Okay, 2, request tier designation letter from law enforcement agency where you register. That's for your client to do, which is the jurisdiction of your primary residence. Okay, often they don't know that. They don't know they can do that. They say, well, they told me. Well, you know, maybe they can get the letter and that would help, because it would be nice to have the letter in your possession so you can gather information from it. And you have a sample of one of those letters. And if you take a look at that sample, it's kind of informative, because it breaks down, one, the client's date of birth, so you can apply the birthday rule this year if you need to. It has their CII number, which is important for the criminal background, and it also designates a tier or does not. So that's important. Number 3, procure proof of current registration from law enforcement agency where you register. Now, this is an interesting one, because this gets mucked up. Some agencies don't really understand what that is, you know, or if they do, they hold it back for reasons unknown. But it's not their annual registration. It is a specific form, as we've said before, 8050. It's got to be attached to the petition. It's not for law enforcement to say, we're not doing that, because let's just say that your status is to be determined. They determine eligibility. They don't apply the law or tell you what the DOJ is going to do. And so that needs to come forward. It needs to be given, it needs to be issued so that you can forward your petition. Obtain a live scan, as we've spoken about, that's number 4, and know the risk level if one has been determined, okay, prior. And you can get that from the static 99, which is a psychological evaluation, a so-called objective evaluation, the stable 2007, which is a dynamic or a comprehensive psychological evaluation, and risk assessment. All these things usually take place before sentencing. And well, not necessarily the static 99, but the stable and the comprehensive are, let's just break it down like this. The comprehensive psychological evaluation risk assessment beforehand. The static 99 usually when in custody, and the stable 2007 usually done through sex therapy. You can find these things, and it's really important to get them and to study them. And if you have to get something new in order to rebut them, to do it early. Get somebody who really knows what they're doing, a forensic evaluator. Anyway, unless anybody has anything else to add to this, I think I'm done with this slide. We can move on to the last one. And, there we go. Finished.
That's great. Thank you, Chance, so much. And Carlton, if you all didn't notice, Carlton and Chance and I are a real team, and we work together a lot with Axel under that umbrella. So we've made several presentations now about the tiered registry law, though this is the first presentation to practitioners, and we're so happy to be able to talk to you. Chance and I did a few months ago. We actually made a presentation, and it's available on the Axel website. That was really for a public and, you know, registrants and family members, et cetera, who are not legal professionals. And we went over the specific forms, because there are forms for this. So I know somebody in the chat room asked us to mention the fact that there are forms. The Judicial Council came up with these forms. And the great thing is they actually asked the public to comment on those forms. And they did make many improvements to the forms before they were finalized. Not to say that they're perfect, but at least they're better than they were. And we're all working with these forms. There is a question for you, Rita. Will this PowerPoint be added to the materials?
Yes, I can see the chat. Thank you.
Okay,
so we're in the question and answer period now. We're going to continue till 4:30. And Janice has answered all the questions directly. But what we're going to do, I am going to share some things, raise some questions I know have come up with other discussions. And then time permitting, we'll go through the questions that have already been answered so everyone can benefit from them. So the first thing I want to share, hold on, is a spreadsheet that the statewide reentry folks have put together, or want to put together, with service contacts. That's this blue, pink, and green, oh no, sorry, the pink and green sections. So what we're hoping is that for each county, we will have be able to list what's the easiest way to serve people, basically. If people can contribute information, we will fill it out and make this available to everyone. You have a link to it in your materials. This part will have public defender contact information and other advocates information that's primarily for directly impacted people seeking help. I want to invite Michele to just kind of take the floor and share your experience in San Diego, what has worked, what hasn't, and what you think you can share to help practitioners taking this on as a new thing.
Yeah, so we started working on SB 384 legislation long before July 1st in anticipation of all the different issues that we would be facing. And we actually, in identifying potential registrants who would be eligible, found 30 individuals who were eligible for a certificate of rehabilitation, which was the previous mechanism for removal from the registry, now no longer is because of the tiered system in place. And of those 30 people, they were eligible for removal, but come July 1st would have been in tier 3 and ineligible for removal. So we collectively, as our unit, pulled resources and filed certificates of rehabilitation for all 30 individuals, 14 of which required an equal protection motion because there were certain offenses where if you were convicted and sentenced to probation, you were ineligible for an expungement and then therefore ineligible for a certificate of rehabilitation. However, if you were sentenced to prison, there is no requirement for an expungement to get a certificate of rehabilitation. Therefore, if you went to prison and had a worse sentence, you were eligible for a certificate and thus removal from the registry. But if you got probation, which was a lesser sentence, you were not. So similar to the equal protection issues that Janice was speaking to earlier about how, the 288C is for lesser conduct, yet it's in a higher tier, doesn't make sense. I fully support moving forward with that litigation, and I hope that that's successful. Because we were successful in San Diego to have a judge grant all 14 of those equal protection motions, and all 30 certificates were granted before July 1st. So saved me a lot of work on the SB 384 petition end, but then when July 1st hit, we have a very streamlined process that has been put in place after a lot of work with collaborating with the DA's office, the bench, the court operations manager, and the 10 different law enforcement agencies that exist in San Diego. And essentially, we have an electronic filing petition process whereby I file an electronic petition that gets sent via Adobe Sign to first the law enforcement agency, and then the district attorney's office, and then the court to pull the file, and then the judge to review, and then the clerk to stamp the final order. And then at the very end of the transaction, everybody gets a copy of it, and then that gets printed and put into the court file. And along the way, when it gets sent to law enforcement, they have an option to upload. So I upload the proof of current registration as well as the CR 415 discussed earlier. And then when it gets sent to the law enforcement agency, they do their check and they upload the checklist that's in the materials that I provided, and then it gets sent to the DA. And which
let me just clarify, the checklist meaning it's the law enforcement response.
Correct.
It's the CSAR form that Chance was talking about. And
Correct.
basically in the law, it's basically just referred to as the law enforcement agency's response to the petition. Is that fair?
Right. They refer to it as a checklist, but in our world, yes, that is their report that they file. And then the DA files their response, either no objection or objection. In our county, because we have this unique electronic filing process, if there's any objection at all, there's a status hearing set just so that we can salvage the transaction rather than there being a summary denial if it was improper and having to refile everything. So we get a status hearing, and then at that status hearing, if the summary denial is appropriate for whatever reason, you know, maybe the client got arrested since filing the petition and, you know, they're in custody pending charges, then that would, you know, get resolved at the status hearing. But if it's for an objection based on community safety, then there would be, sorry about that. There would be an evidentiary hearing set at on a date agreeable to all parties. I actually have 2 status hearings set for Thursday, one of which is definitely going to be an evidentiary hearing, and the other is going to be hopefully resolved. I've sent over some mitigating information, but we will we'll see what the DA's response is on that. Like we said earlier, I filed over 60 petitions, 23 have been granted, and I've gotten law enforcement responses from all, but I think 1 or 2 that I just filed today, and the rest are pending responses from the DA.
Have you had evidentiary hearings on that standard? Communities' safety would be enhanced by continued registration.
I have a status hearing on Thursday for 2 objections based on community safety. And 1, I'm waiting to see if the DA is going to back down because I've sent over a lot of mitigating information that I've received since, you know, the conviction is very old, obviously. The other one, it does not matter what I present. They are going to be objecting and we are going to have a hearing. And I'm actually kind of excited. I think it's going to be fun because, you know, new, different, first time doing something. But no, I mean, it's a great case. There's been no conviction. It's actually, I kind of understand why they're objecting. He has an offense from the 80s, and then 10 years later, he has another offense that didn't result in something that would put him in tier 3 because the charge was dismissed. But had he been convicted, it would have been tier 3. So it's a little concerning. And then he had another offense and he went to prison for 4 years. So there's a lot of reasons why I can understand that they would be concerned.
Okay.
But he's conviction free since 2000 and got a certificate of rehabilitation. So we've got a lot of really good stuff to work with that we can argue. So we'll see what ends up happening with that.
So that's in the future, the evidentiary hearing experience.
That's great.
On follow-up to make sure if once you get it granted, how do you make sure they're off the what steps would you suggest to practitioners?
So in San Diego, our court IT has worked closely with directly with the DOJ, and they have created this tech system where by entering certain data points like the name, the date of birth, the case number, the CSAR petition number, things like that, and entering it, it automatically gets uploaded or gets updated on CSAR that particular person should be removed. And then I have a contact at the DOJ that I would reach out to when we receive the certificate of rehabilitation court orders. I would send them to him and ask to be CC'd on any of the termination letters that are sent to the client. And I believe it's in the written materials. There are example termination letters from the DOJ. I have since tried requesting those or submitting the court orders terminating probation, terminating registration, and then I got pushback because they want there to be a very specific process used from the court sending information directly to the DOJ rather than it coming from me. So in the alternative, what I've done is I've just assumed that the court is doing what they're doing, which I will say court operations manager is on it. And then whenever I get the order, I send it to the same contact and I simply request a copy of the letter terminating registration that gets sent to the client. And he's been responsive about sending them to me. They haven't come as fast as I would like, but I have received them and I have been able to confirm that people have been removed. And also I've noticed that there are the individual that I have petitions granted that I may not necessarily have the letter, but I see that are no longer on Megan's. website. So I have seen that they are taking the steps to remove people properly.
Okay. Thank you. Sorry. Thank you. So another issue is, I know at one point in an chance, but this is for anyone, when you gather all the information that you helpfully, listed, before you file, you might want to take some steps like record clearing, correction. Do you want to maybe even moving? That would be Janice. If anybody want to comment on that.
I think I can speak to that. So on the Fresh Start unit, I am the point person for SB 384 petitions, but I'm also part of the core unit that does expungements and 17B reductions, as well as Prop 64, Prop 47 reductions, certificates of rehabilitation, a variety of post-conviction relief. And so right now, my searching is through people who are strictly eligible based on their current offense. But once I get through the initial review of people, my next plan is to go through those, the 243.4s and the 311s that are felony convictions, and try to get those reduced per 17B to see if those tier letters change from 3 to 1, which I believe Janice has had some success in reaching out to the DOJ and providing the necessary documentation to ensure that they are properly designating their tiers. So kudos to Janice. But also, you mentioned moving. So the law requires that you petition in the county where you reside. And I recently had a conversation with RDA, who holds, their office is holding the position that those who live out of state are not eligible to petition while residing out of state. So I have a client who was convicted in San Diego, moved to Oregon, has been doing fabulous, offense-free, and she has indicated before, she'd indicate just file it, we'll work it out. But now she's indicated that her office is taking a position that they're going to oppose, because the language of the statute specifically says file in the county where you are registering. So if they're registering in Oregon, they have to petition Oregon, but there's no tiered system in Oregon. So what is that client supposed to do? So,
Michelle, if I can interrupt here.
Of course.
Yeah, I totally agree with you about people who have moved out of state. I mean, even though they were convicted in California, the fact is, if they move out of state, and I answered a couple of questions about this already in writing, so I think people are interested, which is, if you're convicted in California and you move out of state, you're automatically removed from the California registry. So guess what? Our state doesn't have jurisdiction anymore. How can they remove you from the registry when you've already been removed? Now, it may not be for the reason you want to be removed, but you're not here. And so I have talked to some folks about moving back to the state just for the purpose of petitioning for removal, because in some situations, and folks who are listening to this, it's not all situations, but in some states, the only reason that you're registering in that state is because you were required to register in California. So, but that's not universal. So people need to do their homework ahead of time to make sure of that. And in those situations, I have recommended to people, they move back to California, right? They register here and then they petition for removal. Of course, one of the big unknowns is, how long do you have to reside in California before you can petition for removal? And I don't know the answer to that question, but I know somebody's going to test it soon.
Oh, okay.
And then Janice, you've recommended that a client switch counties, move out of county too, right? You want to talk about that?
I'd be happy to, Rita. Look, Orange County has been outright hostile to registrants for so long. And I know back when certificates of rehabilitation, and I had a client and I said, I am not going to file a certificate of rehabilitation unless you move out of Orange County. And he waited for 2 years. He finally went across the county line to Long Beach, filed his certificate, and it was granted. So I think Orange County is going to act the same when it comes to petitions. I hope I'm wrong. I do have a couple of clients who are from Orange County that don't want to move, so they will be my test cases. But and another county that I've heard of, this is just a rumor, supposedly Riverside County has put out there into the universe that in fact they're going to object to every petition, no matter what. So we're just passing on data points, folks. You make your own decision.
Yeah,
So,
we just got to gauge. We just got to gauge, you know, which jurisdictions do what. But all these suggestions you're hearing are good suggestions, and this is why lawyers are lawyers. They figure out how to accomplish these things. So I think we're moving in the right direction. But there may be some jurisdictions that are a little bit rough. So
I have another question. Issue, the to be determined tier assignment letters. So there are two questions. Do you have to wait until they assign a tier before petitioning? And if not, how do you fill out the petition?
okay, so the answer is no. So you don't have, the law doesn't say that.
Wait a minute. Well, you say that, and actually I agree with Chance. The answer is no, but you get different results. So Chance, why don't you tell me about your wonderful result?
Well, yeah, no, I think I did go over that result. I got a good result doing that. Now, you know, who knows in the future? I mean, you know, there's what we do, and then what gets appealed, and then there's what courts say. But right now, the answer is no. Okay, for me, and you know, you may want to think about it. If it's an in-state conviction and the classification can be determined on, you know, without the DA or the DOJ confirming it, then what you do is you put on the petition where it asks what tier it is. I know on the petition itself on the form there's no TBD. You just put it right after the line. You just put it in there yourself, TBD, and then mark the number of years the person registered. Okay, and that's that. And then the rest is going to be between you and the district attorney and the court.
Well, I've had a different experience this week, and it's Contra Costa County. I'll just put it out there because they're adamant that if a person's got a TBD letter, that they are not going to allow it to go through the courts. And I did my best to argue otherwise. I filed the petition. I've asked for continuance, hoping that this registrar will get his tier designation sometime soon within the next 90 days. But of course, there's no guarantee, at which point I'll just request another continuance. But folks, this is the thing that really I think is so illogical. I don't know how many people know, but the California DOJ had more than 3 years, actually 3.5 years to determine somebody's tier designation, 3+ years, okay? So the legislation was signed into law in October of 2017. And so starting on January of 2021, supposedly, the tier assignment letters were going to be available. So they had over 3 years to do that. In addition to which, they were able to hire 60 new people, new employees for this purpose. And yet now we're being told in so many cases, your tier has yet to be determined. And I'm really not happy with the fact that I've got somebody convicted of a misdemeanor sex offense, and Contra Costa County is telling me, nope, we are not going to allow this petition to be processed. And he's not the Rosa Parks plaintiff, or I might file a lawsuit right away. I'm looking for my Rosa Parks plaintiff who would have a different criminal record than this person. But the fact is, he's only been convicted of one sex offense in his whole career. And, you know, it just makes no sense. Why do we have to wait for DOJ to do something? And, you know, the law does say they have 24 months or up to 24 months. But really, so again, for somebody convicted of a misdemeanor sex offense, you're going to make this man wait for 2 more years before you're going to allow even his petition to be processed. I think it's unconscionable.
There's a question, is there anything we can do to push the DOJ to finalize tier designations?
So I've been in contact with the DOJ, and I've been trying to encourage them to find tiers for people who will place in the tier to be determined category. And the response is the same every time, that there's, you know, you can't jump the line, that we're going through everybody as fast as possible, and that, you know, you can't do yours ahead of somebody else because that won't be fair. But my contact, who I speak with very frequently, did indicate that they, you know, they acknowledge that the law allows for the 24-month time frame to make a determination, but that they believe that the rate at which that they are tiering will put them well in advance of the the 24-month deadline, because they're looking at it as from the January 1st date, which is when the law took effect, which is, I know, Janice, I know.
Sorry.
But they're looking at it from January 1st. And so the way that he talks, it sounds as if they believe that they have until 2020,
January 1st, 23.
thank you,
Right, yeah.
2023 to get everybody tiered, and that they have 24 months to do so, but that they're going to do it well in advance of that. So
Okay, thank you.
Yeah, one comment to that, and you know, Janice and I have been through that dance before, and we ended up at that unit at the DOJ talking with them and their staff because we were suing them. You remember that, Janice?
Oh, sure.
And that was because they were 5 years behind at that point. So
not on this issue. Let's be clear. So there was a law out there that said California DOJ had to add the year of conviction and the year of release to people's profiles on the Megan's Law website. And honest to God, I was told that, oh, it's going to take us 7 years to do that. 7 years, right? And we sued them. Chance and I sued them. And what do you know, it was done in 6 months.
pretty fast.
So I don't know. I mean, at some point, and I hope it's not January 23, that we have to wait till then, that we file a lawsuit and say, what the heck? Because folks, what are we going to do if they don't meet their deadline? Other than sue them? I just don't know. I would like to,
On that point, I'm just, oh, sorry, quickly.
yeah, I would just like to say that what I've noted about people and getting the TBD letters, most of the time is people convicted in military court, out of state, federal government, and also older convictions in California. So, I mean, like the fellow convicted of the misdemeanor offense, it was like 25 years ago. And so I don't know why California DOJ is waiting so long, especially for the in-state offenses. It makes a little more sense to me for those out-of-state convictions, military convictions, but yeah.
Okay, so we, in the next couple minutes, are there any of the questions that you answered that you think you would like to share? It'd be helpful to share to the audience.
I know there was one question, I don't know if it was answered, but there was a question about if you have a 20-year offense and then you had a 10-year offense, what happens? So if you have a 20-year offense and then a 10-year offense, the time starts running after release from custody on the 10-year offense, but the time you have to register is for whichever one is longer. So then it would be for 20 years, just in case anybody was curious about that.
Anything else? I haven't reviewed all the questions, but I see, does custody for purposes of being ineligible to petition and for tolling include house arrest?
Oh, house arrest, interesting. Technically, that's supposed to be custody, right? So I would say upon release of that.
I agree with you, Michelle. And when I answered it, I said unless then they were subsequently put in jail or prison. Because I know sometimes people are put on house arrest and then they go to jail or prison. Yeah. There was a question here that I gave a very quick answer to. It had to do with, it says, can you explain a bit more who was listed on Megan's Law website before January 1 of 2022 and who will be listed after? So the quick answer is that on January 1 of next year, a lot more people are going to be added. And that's because they've cut down the number of exclusions. And in order to be excluded, there's 4 different factors. And I'm not going to mention them now, it would take too long. But that's what a lot of people are facing, especially people assigned to Tier 3. And for whatever reason, either conviction or offense or your risk level, there are a lot of people who are going to be added to Tier 3 that have never been on the registry, on the Megan's Law website before.
Okay, because we're at 4:30, I'm just going to make a couple other, just repeat some announcements, and I'm going to ask Carlton to put up the last slide with people's email addresses so people can contact panelists if they have more questions. So again, for MCLE credit, please fill out the form that I'm going to type in, that I've added to the chat. You can go back up in the chat to find it. The written materials link is also in there. I want to remind you that we have quarterly meetings of reentry legal advocates statewide. The next meeting is January 11th. Everyone's welcome. Send an email to Rita Himes, Rita@prisonerswithchildren.org if you want to participate. And we will be adding the materials to the folder. So I will try to alert you by email, but just double check it again in a week to see the MCLE credit. I will confirm your attendance, but we're a little new to this, so I apologize. It might take as much as 30 days before we actually get you the certificate. So thank you very much. Thank you so much to the panelists. We really appreciate Axel's expertise in particular, and of course, Michele. But I don't think it's very popular in the general public to do this work. And we really appreciate that people are doing it consistently and so professionally. Thank you.
Thank you. Rita.
Appreciate that. Thank you very much.